We are recording.
Okay. Good afternoon. The appellate court for the state of Connecticut is out of recess and back in afternoon session. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Alvord.
Judge Alexander, good afternoon.
Judge Vertifay.
Thank you. And oops. Oh, I'm sorry, Attorney Federman.
I apologize, Your Honor. Good afternoon. Naomi Federman, present on behalf of the petitioner appellant, Mr. Tyrone Robinson.
Good afternoon, Nancy Chupak for the Commissioner of Correction.
Now it's appropriate for me to say thank you, and we're thrilled to have Justice Vertifay with us at the appellate court. Counsel, prior to this argument, you received procedural instructions for this hearing. Are there any questions before we begin?
No, Your Honor.
Okay.
No, Your Honor.
I'm sure both of you have been with us before in this virtual mode. As you know, please mute the mic when you're not speaking. And as always, don't turn the camera off so we can be sure that everyone is present. Finally, starting yesterday, I believe, the arguments of the appellate court are being live streamed. And to the extent that a case involves any protected identifying information that should not be disclosed, we are asking that the counsel parties, the judges, all be reminded to be careful not to disclose such information during arguments. I am going to keep time using the stopwatch on my iPhone. I will give the litigants a 2-minute warning prior to the expiration of their running time. Please let me know, Attorney Federman, as counsel for the appellant, if you'd like to reserve some of your 20 minutes for rebuttal time, and I will record that also. Okay, I think we're ready to go.
Thank you, Your Honor. And I would like to reserve 5 minutes for rebuttal, please. The two issues that are present in Mr. Robinson's appeal are whether there's been a Brady violation, meaning that the state failed to disclose evidence that was both exculpatory and material to the defense. And the second concomitant claim is whether there was ineffective assistance by prior habeas counsel due to that counsel's failure to raise the Brady claim in the previous habeas proceeding. Ultimately, however, the question for this court is whether there can be an examination of the record below and whether there has been a loss of confidence in the original verdict. As the petitioner has put forth, any reasonable examination of the trial court record and the record before the habeas court cannot sustain confidence in the original criminal verdict. The facts are fairly well contained. Habeas counsel for Mr. Robinson issued a FOIA request to the Hartford Police Department in preparation for the second habeas proceeding. As a result of that FOIA request, what habeas counsel received was a statement taken by the Bloomfield Police Department from Mr. Robert Hudson. And in that statement, Mr. Hudson outlines a check fraud cashing scheme that he had engaged in with the decedent from Mr. Robinson's case. That would be Mr. Leonard Lindsay, who is known as Toast. Now, if you recall, during Mr. Robinson's original criminal trial, as the state conceded, there was no forensic evidence linking Mr. Robinson to the crime. There were no eyewitnesses, and the only evidence put forth by the state consisted of alleged confessions by Mr. Robinson to 3 different individuals. Although, as detailed in the brief, those purported confessions were certainly diverse in both facts. They were dilatory on the part of all 3 witnesses, and there was a substantial incentive for the witnesses to testify against Mr. Robinson, most concretely, Mr. Smith, who received substantial consideration in his federal sentencing for the testimony he provided at Mr. Robinson's criminal trial. At Mr. Robinson's criminal trial, as I just mentioned, there were these three witnesses, Mr. Larry Ralph Snyder, Ms. Toya Ellis, and Mr. Eric Smith, who each provided testimony for the state in which they detailed these alleged confessions that Mr. Robinson had indeed committed the shooting. However, these alleged confessions differed in both substance, the manner of that the murder was committed, whether it was premeditated, whether it was a spontaneous act, and again, none of these witnesses came forward without any sort of consideration being offered to them or the potential for any sort of consideration to be offered to them. So now what we have, fast forwarding to Mr. Robinson's second habeas proceeding, is we see that there's this evidence collected by the Bloomfield Police that points to a potentially culpable third party, that of Mr. Hudson. Now, Mr. Hudson was not involved in any of the prior proceedings, but he was called as a witness in the habeas proceeding at issue in this appeal. Now, when he was first called to the proceeding, Judge Newsom advised him that there was a potential for self-incrimination, and thus Mr. Hudson was given access to a public defender who rendered legal advice, and on return to the courtroom, Mr. Hudson decided to invoke his Fifth Amendment privilege not to testify. So what we do have admitted was the original statement to the Bloomfield Police and the cash withdrawals and the fraudulent checks that the Bloomfield Police had compiled that were then made part of the Hartford Police Department's file. And in the statement, as well as which is borne out by the checks themselves, what we see is that the day after Toast was shot, Mr. Hudson empties the joint bank account, the bank account that was the subject of this check fraud cashing scheme, and removes all of the proceeds from the scheme, even though, according to Mr. Hudson in his statement, the arrangement was that Toast and Mr. Hudson would share the proceeds. So what we have is a very unequivocal timeline where Toast is murdered, and then Mr. Hudson removes all of the cash, the total of which was approximately $23,000 from this bank account. So the question for this court, as I mentioned, is whether had the
question, Attorney Fetterman, was the $23,000 what remained in the bank account, or was that the original amount?
That was the original amount,
Right.
and then what
was removed the day after?
Right. So by the end, when the Bloomfield Police conducted their investigation, the account was empty.
Right,
So-
but you said the day after Mr. Hudson removed the $23,000 from the bank account. I don't think he removed $23,000 the day after, unless I misread the facts.
No, you are
Okay.
correct, Your Honor. It's what was remaining at that point was approximately $6,000, and the day after, the exact amounts are detailed in the facts section of my brief, and with the court's indulgence, I can certainly.
That's okay. I just wanted to make sure it wasn't that as, okay, that's fine. Yeah. you can-
I have it right here. So on September 19th, $23,938.75 had been deposited. September 20th, 2002, $10,000 had been withdrawn from the account. September 23rd, $1,000 was withdrawn from the account. And October 7th, 2002, which is the day after Toast was shot, the remainder, which was $6,000, was withdrawn from the account.
Thank you.
So the import of this evidence is that, as Attorney Flores and Attorney O'Connor, who had represented Mr. Robinson in the underlying criminal trial, testified to, had they been aware of this information, they would have investigated and presented a third-party culpability defense. Now, the habeas court in this case found there was no basis from which the court can conclude that this would have led to any sort of admissible evidence regarding third-party culpability. But we know, of course, that that's not what the case law requires, and we see that most clearly in LaPointe, which is cited throughout the brief, which is that the habeas court is called upon to make a predictive evaluation, and that predictive evaluation ultimately goes toward the question of, is the confidence so undermined in the verdict that it cannot be sustained. So here we have a case where there's no forensic evidence, there's no eyewitnesses. The only 3 witnesses who testified that Mr. Robinson had confessed were subject to substantial impeachment evidence. And then at the prior habeas proceeding, where Mr. Robinson was represented by Attorney Rimmer, we have Ms. Ellis, who had been served with a subpoena, refused to testify at court. A capias was issued and subsequently reissued, and she refused to comply with the subpoena, advised the investigator and members of the Hartford Police that she would not be coming in to testify. She would be fleeing to Florida, and she would not be complying with the subpoena. And we have Eric Smith, who also gave testimony against Mr. Robinson, similarly took the Fifth Amendment when he was advised by Judge Kwok to consult with a public defender. As we've argued in the brief, the habeas court, sitting in a civil proceeding, should draw an adverse inference from these witnesses' invocation of the Fifth Amendment privilege. And the only reasonable adverse inference that we can draw at this juncture is that Mr. Smith committed perjury at the original criminal trial, because certainly there's no allegation that he was involved in the murder itself. And the only outstanding criminal liability there could presumably be would be from his testimony at the criminal trial. Now, for Mr. Hudson, Judge Newsom very explicitly advised Mr. Hudson that Mr. Robinson was making a claim that Mr. Hudson was the potentially culpable third party responsible for the commission of the murder. And upon consultation with a public defender, Mr. Hudson invoked his Fifth Amendment right. And of course, for there to be a valid invocation of the Fifth Amendment, there has to be the potential for criminal liability. And here, more than a decade after the underlying check fraud cashing scheme, the only potential liability that could exist would be in relation to the murder.
So let me stop you again. So the direct evidence connecting Mr. Hudson and the murder is the $6,000 remaining in the bank account?
Not merely the $6,000. He had given a statement where he admitted to engaging in the check fraud cashing scheme with Toast. And there
had the statute run on prosecution with respect to that, as I think was mentioned perhaps by the state?
Yes. So by the time of Mr. Robinson's habeas proceeding in 2017, that statute had long run.
Yeah. But the impetus for the murder was the $6,000 remaining in the bank account.
That is the contention. That mainly, I wouldn't limit it to necessarily a dollar amount, but the fact that they were engaged in this check fraud cashing scheme and what was remaining in the bank was $6,000. What happened to the rest of the $23,000? We only have Mr. Hudson's statement that he had given any of that balance to Toast prior to the murder. So I would say the amount would range anywhere from the $6,000 to the $23,000, but that doesn't change the nature of the scheme itself. No.
And as to the habeas trial, when the witnesses, I think you said Smith and Ellis, took the Fifth, when was that?
Ellis did not take the Fifth. She's the one who refused to comply with the subpoena, and then the capias was issued, and finally they sent out Hartford Police, and she took very active efforts to avoid compliance. That was, I believe, 2013, although I would defer to the record, as those transcripts were admitted as exhibits in the 2017 habeas proceeding.
I think that decision came out in 2014, so would you agree it might have been 2014?
That the trial was held? It could well have been 2014, and I will defer to the record because, as I mentioned, those transcripts from the prior habeas proceeding were admitted as full exhibits in the habeas proceeding of this appeal. And the underlying criminal trial was in 2008. Or I would agree, actually, Judge Alexander. It looks like 2014. You are correct.
So again, that would put it outside the statute of limitations for perjury from a 2008 trial, correct?
I would disagree, Your Honor, because the statute has that exception for perjured testimony where the subject of the original criminal prosecution is ultimately found to be actually innocent. And I recognize, of course, it's a very defined legal term of art, but this invocation of the Fifth Amendment was made after consultation with the public defender and accepted by the court. And in order for there to be a valid invocation of the Fifth, naturally there has to be a potential for criminal liability. And there's been no suggestion by either the commissioner or the petitioner that Mr. Smith was somehow himself involved in the murder. So the only sort of liability from testimony, the only reasonable inference we can draw is that it relates to his testimony at the criminal trial, not to the murder itself.
Well, that's what you're arguing.
That, yes, that is my argument.
All right, thank you.
So again, when we consider the evidence of Mr. Hudson's involvement in it, oh, I'm sorry, Judge Albert, that was blurry. Is it two minutes? Oh, I'm sorry, I think you're muted.
2 minutes left, Attorney
Okay.
Federer. Sorry.
Thank you. So the import of Mr. Hudson's statement is not only that there's a potential for a third-party culpability defense that defense counsel themselves testified to they would have raised, is that there was such a weakness in the state's original case. Their alleged motive for the murder was a year and a half before the killing. Toast had touched Mr. Robinson's girlfriend's butt inappropriately at the club, and a year and a half later, despite witnesses testifying peaceful interactions between Toast and Mr. Robinson, that a year and a half later, Mr. Robinson is so slighted by this offense that he commits this murder. And again, the difficulty, as I've explained in the brief, is that we have Detective Bilbo getting on the stand and saying, we have done an exhaustive investigation and we find no other possible suspects, no other possible motive other than this interaction that Toast had with Mr. Robinson's girlfriend that so enraged Mr. Robinson that a year and a half later, he commits this murder. So the timeline again is 2002, the murder's committed. Mr. Robinson is not arrested until 3 years later. So a year and a half prior to the murder, the incident with Toast and Mr. Robinson's girlfriend at the club, 2002, the murder, then approximately 3 years later, Mr. Robinson's arrested, and then the trial in 2008. And we have Detective Bilbo testifying that of the exhaustive measures that are undertaken. So, oh, is that my time, Your Honor?
Yeah, you can finish your sentence.
Oh, thank you. So, had the jury been afforded the opportunity to consider a check fraud cashing scheme had provided motive for a potentially culpable third party, certainly the jury, employing all the common sense that we expect juries to, would have found that a more substantial, reasonable possibility, and that could have invoked in them a reasonable doubt as to Mr. Robinson's guilt. Thank you.
Thank you. Attorney Chupak.
Good afternoon, Your Honors. Nancy Chupak for the Commissioner of Correction. The habeas court properly denied the petitioner's claim of a Brady violation because the petitioner failed to demonstrate that the state suppressed material exculpatory evidence. First, the petitioner failed to show that Hudson's police statement and the banking records by themselves constituted material exculpatory evidence. The petitioner did not provide any evidence, even indicating that Leonard Lindsay, the murder victim in this case, and Hudson's Lenny were the same person. He did not even show that the murder victim met Hudson's description of his Lenny as a flashy dresser who drove a black Mercedes or BMW, frequented the bar with no name, and went by the name Lenny. Indeed, there was evidence at the criminal trial that indicated that the two were not the same person. And that evidence was that the victim drove a Mazda MPV minivan, not a Mercedes or a BMW. Even assuming that Lenny and Leonard Lindsay were the same person and that the police statement and the bank records constituted favorable exculpatory evidence, the documents did not establish a direct connection between Hudson and the murder. At the very most, the petitioner showed a possible motive on Hudson's part to killing Lenny, but he failed to show at all that Hudson had the opportunity to commit the murder. And the habeas court, as the habeas court noted, the petitioner did not offer any evidence that Hudson was even in Connecticut, let alone Hartford, around the time of the murder. The fact that money was drawn the next day is not enough, particularly since the petitioner failed to show any evidence of who withdrew that money. And nothing whatsoever, no evidence that Hudson removed it, or if he did, that he didn't split it with the real Lenny. And just as a note here, defense counsel did not say that based on this evidence, they would have raised a third-party culpability defense. What they said is they would have investigated had they known about the statement, police statement, and the bank records. The petitioner seeks to bolster the documents by having them viewed through the lens of Hudson's invocation of his Fifth Amendment privilege, and specifically the adverse inference that he argues can be drawn from Hudson's invocation. Even if the habeas court could use Hudson's invocation of his Fifth Amendment privilege to bolster the documents and render them material for Brady purposes, which the state questions in its brief, particularly in light of the fact that petitioner has not cited a single case where this was ever done. Even if he could do that, and even if he met the road test such that the habeas court could draw an adverse inference from Hudson's invocation, based on this record, the adverse inference would not be that Hudson was the third-party culprit, as the petitioner contends, because Hudson never invoked the privilege in response to any question about the murder, because the petitioner never asked him any questions about it. He invoked the privilege in response to the petitioner's question to him about the fraudulent check cashing scheme. And this is a big difference between this case and the cases that the petitioner cites, particularly Joyner and Deutsche Bank. In Joyner and in Deutsche Bank, the investigator and Paquette were asked specific questions about the tape and the file documents which they were accused of having fabricated or fraudulently filed. That was not the case here. Although the petitioner argues that the statute of limitations expired on the check cashing scheme and thus the invocation had to be about the murder, there is no evidence, first, that Hudson was aware that the statute of limitations had run, or even if he did know, he could have been concerned about perjury since he gave his police statement under oath and the statute of limitations for that crime hadn't run. Moreover, although the petitioner argues that Hudson's invocation had to pertain to Lindsay's murder because the habeas court informed Hudson prior to his invocation that the petitioner was pointing his finger at him as the person who killed Lindsay, and thereafter accepted Hudson's invocation, his argument fails because the court also told Hudson that his testimony at the habeas trial could implicate him in the murder or other crimes, and therefore he really wanted him to speak to an attorney. Thus, the court did not limit its caution or its acceptance to the crime of murder. It was any crime. There is also nothing in the record as to what the Hudson and the public defender talked about, and therefore why Hudson invoked his privilege. Again, the petitioner's questions to Hudson were not about the murder, they were about the fraudulent check cashing scheme. Although the petitioner further argues that the court could have drawn an adverse inference against Hudson's credibility as a result of his invoking the privilege, his argument fails because Hudson did not provide any substantive testimony at the habeas trial outside of stating what his address was. Thus, unlike Gold, Deutsche Bank, and Joyner, which the petitioner cites, here, there was no testimony by Hudson, and particularly none about the murder, for the court to assess Hudson's demeanor or the substance of his testimony from which to draw an adverse inference regarding his credibility, and then use it as an adverse inference to gauge the materiality of the documents. In Deutsche Bank, Paquette made prior admissions. In Joyner, the attorney testified. Because the petitioner failed to show the documents themselves were material, and he failed to show that any adverse inference drawn from Hudson's invocation had any significance here, and specifically gave rise to an inference that Hudson was the third-party culprit, combining them still did not call into question the outcome of the petitioner's criminal trial and render the documents material. This is especially true in light of the state's evidence at the criminal trial. The state's evidence was not weak. Rather, it included motive evidence, and it wasn't just about touching the petitioner's girlfriends behind at the club. There were rumors after that club incident that that Toast, Leonard Lindsay, and the petitioner's girlfriend started a sexual relationship, which angered the petitioner. The state's evidence, besides motive evidence, included statements to the police from 3 people who did not know each other, who independently told the police that the petitioner confessed to them to killing Lindsay. And additionally, Larry Rafe Snyder, who was imprisoned with the petitioner in Pennsylvania, testified and contacted the police, knowing that he was not going to get any benefit from doing so. As noted in the state's brief, he was serving a lot of sentences in federal penitentiary, and then after that, I think he went to Arkansas, who started a 40-year sentence. Additionally, Larry Rafe Snyder drew a map of the area surrounding the murder scene based on his conversation with the petitioner, and the police noted that the map was completely accurate. Thus, for all of these reasons, the habeas court properly denied the petitioner's Brady claim. I will rely on my brief with regard to Attorney Rimmer, but with regard to just one aspect, and that is Ellison Smith. The petitioner's claim that Ellison Smith's conduct at his habeas trial should be included in the prejudice determination the commissioner takes issue with, because he never raised this argument before the habeas court. So it's a brand new argument. However, even if it's considered, his claims with regard to both are meritless because they amount to pure speculation. The petitioner's claim that Ellis ran away rather than comply with his subpoena to testify at his first habeas trial because she was guilty of perjury is pure speculation. He presented no credible evidence of that fact. I think there was a marshal's testimony, but the marshal's testimony was based on hearsay upon hearsay. With regard to Smith, we have no idea why he invoked the privilege. Neither the petitioner nor the respondent asked him any questions. He didn't testify at all. Consequently, the habeas court properly denied the petitioner's third petition, and the commissioner requested this court affirm.
Thank you, Attorney Chupak. Attorney Fetterman, you have 5 minutes remaining in rebuttal time.
Thank you, Your Honor. The respondent's argument overstates both the petitioner's burden on appeal as well as the state's case in the underlying criminal proceeding. So while there were 3 witnesses, as I've already mentioned, Ms. Ellis subsequently refused to comply with the subpoena, and there was testimony by the marshal that he went there to serve her along with Hartford police, so engaging in a very substantial evasion of that subpoena. Mr. Smith testified even at the underlying criminal proceeding that everything that he alleged that Mr. Robinson disclosed to him, he had already known about from media accounts and about the murder itself. And again, that disclosure was allegedly made 2 years after the murder. And as for Mr. Raff-Snyder knowing so much, that's not surprising either. He was incarcerated with Mr. Robinson, and as defense counsel attempted to elicit in cross-examination, had access to Mr. Robinson's legal paperwork, as Mr. Robinson, although deferring to the record, Mr. Raff-Snyder, of course, denied this, Mr. Robinson had sought assistance in his pro se filings, and Mr. Robinson at sentencing, you can hear him reiterate the claim that Ralph Snyder had seen Mr. Robinson's legal paperwork. So the fact that he would note details about the crime certainly is not surprising considering the context in which their relationship arose. And
Could you please respond to the point made by Attorney Chupak that Mr. Ralph Snyder had something to gain?
I don't think there's anything beyond what this court and the Supreme Court have always recognized, that simply because there's not an overt promise, that the fact that an informant or is coming forward to testify is not without his hope for a benefit in exchange for that cooperation. So simply because nothing had potentially materialized for Mr. Ralph Snyder prior to trial, or so that he could honestly testify during cross-examination that he had not received a benefit, does not eviscerate his hope for leniency in those very substantial sentences as detailed by the state's attorney. So to say that he didn't have an incentive does not mean that simply because he hadn't been made a concrete promise at the time of trial does not mean that he did not proffer this evidence with the hope. And we see that language repeat in the Connecticut Supreme Court case law, inherently suspect, right? That's how we view informant testimony, which is what this was. It is oh, I'm sorry, Judge Alexander.
He was not serving a Connecticut sentence. He was a federal prisoner.
He was a federal prisoner.
Thank you.
But certainly that doesn't, so was Mr. Smith, and he received substantial consideration in exchange for his testimony. His federal sentence was reduced to about 50% based explicitly on his cooperation. So to point to the testimony of these three witnesses and say this case is overwhelmingly strong is simply inaccurate. And as the Connecticut Supreme Court stated in Henning, this court has previously recognized in this context a murder prosecution predicated primarily on a defendant's alleged or actual admissions, and in which there were no eyewitnesses and no forensic to the crime, is not a strong case, and is therefore one in which prejudice sufficient to satisfy the materiality standard is readily shown. And I would stand by my argument that the motive put forth by the state was this inappropriate touching at the club that a year and a half prior, because even though at trial, the state raised the specter of this relationship, several witnesses testified to interactions between Toast and Mr. Robinson in the intervening time period that were peaceful, most recently several days before the murder, where Miss Ellis had called Toast to the house, presumably to buy marijuana from him, and there was no altercation at that time. So I would stand by that assertion.
That wraps up your time, Attorney Fetterman. Did you want one last conclusory sentence?
No, thank you very much, Your Honors. I really appreciate your consideration.
Okay, thank you both, and we will conclude the arguments on the first afternoon appeal. Thank you.
Thank you.